Our session will start in a couple of minutes. It's already more than 200 live attendees now with us, and I'm waiting for my presenter, starting from the managing partner of S.Majumdar, Mr. Subhatosh Majumdar. He will be speaking on innovation for green future, and after that, the Mr. Utsab Banerjee. His topic is inadequacy of IP laws to incorporate growth of artificial intelligence. He is the manager of Cognizant Technology Solution, and after that we have Mr. Ayon Roy Chaudhary. He is the vice president of Saregama India Limited. Mr. Dinesh Jotwani. He is a co-managing partner of Jotwani Associates, and Mr. Shumantra Mukherjee, director of KPMG. We will be connecting with one by one presenters.
Hi everybody. It's thank you all for waiting for us so patiently. And as you know, topic would be on artificial intelligence and the technological glitch that we are facing these days. This proves that we seriously need very good standard of AI to help us during these webinars. Okay, so today my topic would be the inadequacy of IP laws to incorporate growth of artificial intelligence or AI. Brief background: I work for Cognizant Technology Solutions. I'm manager in the legal team, and I basically work, very closely with the IP creation practices within the organization. I'm an Indian patent attorney and also a engineer and turned lawyer. Okay, so that's it. So we would be covering a vast number of topics today, and all of these views that I would be sharing. It's my personal. My company might not, absolutely agree to what I'm saying, but this is a research that I have done over the last couple of weeks on AI, and the result would be, depicted to you today. Okay, so the topics that we would be covering is the definition of artificial intelligence, then the evolution of AI, specifically from intellectual property point of view. Then AI patent proliferation, the patent numbers are increasing drastically. Then what are the issues in the IP regime, regarding artificial intelligence in the present IP regime? And then the problem solution approach. So the problem solution approach, typically, we hear while deciding on obviousness of a patent or inventive step of a patent. But I really love this term problem solution. It can be applied to any field of life. This term AI, it was coined in 1955 by John McCarthy. He was a professor of Stanford University and a Turing Award winner, and one of the first proponents of artificial intelligence. Then after 1955, it's long, so we have almost past 65 years, and now AI is at helm, and we are investing a lot. The total humanity is investing a lot into bringing AI to newer heights to help us in almost all facets of our life. So let us understand what is the definition. So I would not be talking too much on the technological part over here, because I would be talking more on the legal part. So the definition that I have put in is from the WIPO. So it's AI is generally considered, it's a discipline of computer science. So it is aimed at developing machines and systems that can carry any task or any work. It can do any work that would require a human intelligence, so it can do on its own. So machine learning and deep learning are two subsets. So this is how even human beings learn. So if you are a small kid, if you see a small kid, he or she learns from the environment. They keep on learning and learning and understand what is correct and what is wrong, and that is the way that person becomes mature. The same principle applies for machines, specifically for AI machines. So now AI is perceived as a synonym for deep supervised machine learning. So one of the most important facets of artificial intelligence is it's supervised. So still what the AI that we see is supervised. It's supervised by human beings, and the machine learns based on the supervision of a human being. Okay, now let us understand briefly about the evolution of AI. So again, there are three subsets or three stages of AI evolution. So again, this is according to one kind of technological jurisprudence, we can say. This may vary from people to people, from country to country, but broadly speaking, right now we are in the ANI stage, that is the artificial narrow intelligence. So what is it? It's a AI, or it's a machine which basically specializes in only one area. So it's like the Deep Blue, the machine or the computer that beat Gary Kasparov in chess. It's long back, but AI, as of what we can see right now around us, maybe 99% of the AI around us specializes to do only one kind of task. The same AI which can beat the chess champion cannot figure out how to drive an autonomous car. So still now, it's very narrow. The application is narrow, and it's only restricted to one field, and it requires huge amount of human supervision to perfect its outputs. The next stage comes the artificial general intelligence. So it is it is defined as a general mental capability that involves the ability to reason, plan, solve problems, think abstractly, comprehend complex ideas, learn quickly, and learn from experience the same way human beings think. So that is called artificial general intelligence. We have started, or the humanity has started its journey from ANI to AGI, but AGI still is a long way ahead. Because most of the machines that we right now handle, or most of the AI that we now use in our daily lives, still requires huge amount of human supervision. And the last stage of development is artificial super intelligence. So it is something that is much smarter than human brains, and it can in practically every field. So just like a human being, it can think much faster, it can solve much more complex problem. Even it could have wisdom and social skills. So the challenge in achieving this artificial super intelligence stage is the computing power. We as human beings, we have not yet devised such computers which can enable an ASI to work seamlessly. So that is what would be the requirement of the future. More computing power can basically generate higher level of intelligence. It's directly proportional. From 1998 to 2017, I came across a couple of graphs showing the proliferation of AI related patterns. So no longer we can sit behind and say that yeah, AI is something that is there and it's okay. It's not so. It's all percolating. It's percolating to all areas of our life, and all companies, all universities in the world have started working on it. And if you see the number of patents, starting from 1998 to 2010, the curve was flat, and then from 2010 onwards till 2007, there has been steep rise. And China is one of the largest filer, followed by United States, Japan, and Korea. All of these companies are filing hugely in this domain. So no longer we can say that it's just another field of science. It does not require any special, I would say, notice. So that's not what is the case. So the beauty of AI is it can penetrate each and every field of science and technology. It can infiltrate each and every angle of human existence. So IBM is one of the largest filer, followed by Microsoft, and then there are a plethora of Chinese universities who are filing lot of patents in AI related technologies. So now, till now, that point that we were talking was, I would say, quasi legal, quasi I would say technological part. This is not what was the the aim of the session. The session was is the present IP regime sufficient enough to protect AI and to ensure growth of AI in future? Okay, so let us understand what are the issues in the present IP regime. So I have classified the problems into three types: patents, copyrights, and data. So why data is very important, so I would talk about it in my later slides. And copyright, whatever problem you see can be replicated for designs, industrial designs, because they are very closely related. So for patents, you know, very few questions starts coming in. First, a human being and a machine jointly invents something, wherein the inventive concept is jointly provided by a man and machine. So who should be the owner of it? Should the man be the only owner, or should the man be named as a co-inventor as that of the machine? So that is one question, because the essence of the law is very clear. All true and first inventors has to be named in the patent. Right now, the laws across the world does not allow for a non-human entity to be a inventor as such. But that is the question for the future, that is the law sufficient? Then the next question comes when the AI reaches the level of AGI and ASI, and it starts doing, developing inventions and creations and other things on its own. So what happens to such patents? So if a patent is solely invented by machine alone without any intervention whatsoever from any human being, who should be the owner? Who should be the inventor? And then who should be the owner of such patents? So a machine can invent, who would be the owner of such patents? That is another level of question that needs to be answered. Okay, the last part, or the third part in such question is when one of the major hindrances to get a patent, or the tests for patent, we know its subject matter, then its novelty, and then its obviousness. So to test obviousness, we have a concept called person having ordinary skill in the art, or FOSITA. And FOSITA, as we all know, it's a qualitative test. It's not absolutely quantitative. So it varies from human being to human being. Who is a person of ordinary skill in the art? So that is a very relevant question in this domain. So uh, now, when a machine invents, um, can we can we construe that a human being would be in a position to be a person having ordinary skill in the art, FOSITA, for judging that invention? Can a normal examiner judge it? Because a machine would be much smarter, much faster than normal human beings in longer period of time. So FOSITA concept needs to be thought about. And then autonomous machines, while inventing and trying out new combinations and new ideas, may inevitably infringe on some patents. So, what happens to those patent infringement issues? So then in the copyright issues, same thing comes in. Artistic work which is autonomously created by a machine without any intervention from any human being. Uh, what happens to the authorship and ownership of such cases? Then deepfakes. So deepfakes are something like the machine creates personalities which are exactly same as that of a existing human being, and through various kinds of visual and audio technologies can recreate motion and a number of activities of such persona. So just think for a scenario, Rajnikant, and if a machine can create a Rajnikant like image, looks absolutely similar, and develops a movie out of it, then what happens to Rajnikant's rights? And what happens if such a creative autonomous machine creates it on its own? Then who would be responsible for such infringement? The last and not the least, the issue pertains to data, because everything that AI that we see around is driven by data. Data is at the core of AI development and AI proliferation. And as we see, there is very less data protection, IP protection in data. I would say data protection is a different thing, but IP protection in data laws across the world. Certain countries have their own sui generis systems, but there is nothing in the global level. We think about patent, copyright, designs, and semiconductor layouts, geographical indications, but we never think that data can be another form of IP. So, do we really require something in that domain? So some of the food for thought. So why it is important for us to think all of the questions that we addressed in the last slide? Why it is so important? So let us understand, like a human creator of AI system. So AI system has to be created by human, and if that system invents or creates something, then human can be the owner of it, not an issue. Okay, but what happens if the human intervention, uh, uh, can we really call him the true inventor or author? The person who creates the machine, and the machine creates the invention or the authorship, or the work, whatever be it, can we really call that human the inventor or author? Is he the true author or true inventor? And then what happens when the human dies and the AI system does not have any death? It keeps on inventing and creating new things. Then what happens? Who owns such things? Who would be the author of such things? Who would be the inventor of such things? Who would be the owner of such things when the human creator of that particular AI system dies? So the human creator may pass it down through the through I would say to his son or his daughter, or maybe his legal heir, the ownership of the machine. But if the machine really invents such thing, do we really, can we really call that heir or this particular person who inherits it the inventor? That's a huge question. Okay, then the same is in an AI, or inventor or author may inevitably infringe on third-party IP while developing such invention or artistic works. Then who shall be responsible for such inventions? And long term, it may happen that all AI machines would not have even owners. So there would be open source machines which would be acting autonomously over the internet without any human intervention or ownership as such. So what would happen to such machines when they infringe on someone else's IP? Okay, and then when the AI machines reach AGI and ASI levels, they would be inventing faster and more easier than human beings. So if equal protection and equal touchstones are provided for AI inventions and human creativity, then it may it may put our creativity or human creativity in danger for long term. Okay, then data is the currency of future, and do we really need another form of IP specifically for data? Because right now, as I told, the data protection or IP data protection is at very nascent stage, and the protection is absolutely inadequate. Okay, so let us go delve, briefly into the problem solution approach. Some of the solutions that I have thought through and I have put it forward. So, the questions that were raised were basically, some of the questions were raised by WIPO. In WIPO published a paper or an issue list on AI ownership of IP for AI in its website, and has asked various countries or
Uh,
stakeholders to give their replies.
Utsab,
Yeah.
just a second. I will take only one moment. Uh, all the present attendees, for all the attendees, those who are facing this audio problem or video problem, please repress reconnect button so that it can be automatically connected. Okay, this is small announcement. And Utsav, another thing is that you have just 5 to 7 minutes left,
Yeah,
and
yeah, sure.
I'm taking three questions for you only from
Okay.
the list. Okay,
Okay, sure,
I'll pose
sure.
the questions. Okay.
Okay,
Thank
sure. So, then the question comes that, patent copyrights that are developed by machine, should have a human assignee. So, without human assignee, it's not going to work. So, the owner should always be a human, because as of now, without human ownership, proper commercialization might be hindered. So, the maturity humanity is right now, we still need a machine or to be owned by a human being, and IP created by that should be owned by a human assigned. But AI machines should be named as inventor or author if they are autonomously creating it. So otherwise, it basically defeats the very purpose of patent law, wherein we say that true and first inventor should be mentioned. But what happens for machines without owners? So a governance mechanism has to be developed for that, a state sponsored governance mechanism. Then if such machines infringing of third owner, then owner has to be liable. So a a deep governance mechanism for all such machines inventing and creating should be developed. Then the next suggestion is for the FOSITA part, we should have a FOSITA developed. So AI for judging inventions of AI. So the examiner and the person having ordinary skill in the art should be AI driven. That's why, so that they can actually judge whether the inventions are obvious or not. And the next suggestion is, can we reduce the lifetime for the patents or maybe the IP that is created by autonomous AI machines, because they would be inventing much easier than human beings and flooding the market with n number of such inventions and, I would say, innovations. And a standard of inventive steps should be different for humans and machines. Without that, it would be very difficult for humans to compete with machines. Okay, for data IP protection law, what is important is all data types, frameworks, data models, all of this has to be covered under a single comprehensive data IP protection law. Without that, people, would be misusing others' data. And if someone creates some data, then his creativity is not actually, I would say, compensated well enough. Then necessary changes needs to be made into contract law for enforcement of contracts entered by autonomous machines. So once the machines become autonomous, they can enter into contracts amongst themselves. So how what should be the, the legal regime to uh, govern such transactions? And there would be confidentiality and trade secret misuse issues if machines are not governed properly. So we would require a specific legal regime for that. So I would just conclude right now. I would take another minute. So why AI is so important in present scenario? If you see AI and COVID, AI is helping us in so many different kind of ways in solving the problem. We have to think it to be our friend. We have to think it as our assistant. We cannot think it to be our enemy. Then the problem starts. So it's doing molecular and genetic analysis to find vaccine cure for COVID. AI-driven robots and strategy for mass sanitization and community healthcare are going on. Then it can also predict spread and effective lockdown period and geofencing techniques. So it can also do that. And it can obviously do running existing businesses with minimal human intervention. Now just think all of this is done by ANI, that is artificial narrow intelligence, is helping us in doing it. Just imagine if we had ASI at this point of time, probably it would have found a cure in couple of days and we would be as normal as ever and working in our office, and we would be taking these calls from our office today. So that's what's the beauty of AI, and we have to provide proper IP mechanism to ensure that AI blooms and AI proliferates. That's it. So these are my resources. Thank you. My mail ID is over here and my mobile number. So anybody, if you want to contact me, please do so. Please don't hesitate. Thank you. I will be taking the questions.
Yeah, Utsab. So the question was, I have taken four questions for you.
Okay.
One is, what is it's a Rohan and Arthendu
Mhm,
asked you that
mhm.
what is posito and e-posito?
Uh-huh. Okay. So Fosita is a person having ordinary skill in the art. So it's basically a touchstone or used to judge whether an invention is obvious or not. So when we file a patent, for a patent application to get a patent, one of the touchstone is obviousness test or inventive step test to how to understand the invention is obvious or not. The patent office thinks, or the law thinks, that a person having ordinary skill in the art, if he feels it is obvious, then it's you cannot get a patent. Now for machine driven inventions, uh, because machines can think in more complex way and better than us in long term, then a human examiner examining such inventions would never feel such inventions obvious. Okay, so that's why the standard, when machines file invention, the examination has to be done by machines. Over there, that's concept of eFosita or electronic person having ordinary skill in the art. So AI system to judge whether another AI system uh, is eligible to get a patent or not. Okay, so next question, please.
Okay. The next question is, it's Bhaskar. Can we say what? Can we say that AI can intervene in our privacy?
Okay, so as of now, we are in ANI stage wherein it's absolutely human supervised. So all the learning, all the activities, all the steps that a machine takes, it's basically human supervised. So getting directly into our privacy would not happen unless a human beings wants to do so. So I want to hack into your data. I want to destroy your privacy. I can use a AI machine, but that's illegal, correct? So in ANI stage, it's very easy. Without human intervention, machines cannot do that, or without human intention, machine cannot get into your data or destroy the privacy of your data. But once we are in the AGI and ASI, then the problem starts. Machine would be acting on their own autonomously without any intervention from human beings. So over there, we would be requiring very strong governance mechanism, state-backed governance mechanism, and over there, specific laws for AI, so that autonomous machines can be controlled under human laws. So that's what would be required in future.
Okay. And the next question, the last question is, it's a Shornendu Das. When you suggest data leads to proliferation of
Uh-huh.
the IT,
Uh-huh.
how much emphasis is put on its safeguard as well?
Yes, sure. So, very relevant question. So, data protection, obviously, throughout the world, if you see, it's now GDPR, starting from GDPR, US Privacy Acts, and the Privacy Act and the Privacy Bill in India, Data Privacy Bill, everything is coming up. And throughout the world, people have understood that data is very important for human evolution, and protection of data is very important. The privacy and the protection of data is very important. But from intellectual property point of view, what data means is the feeder, the food for AI systems. So AI systems would require huge amount of data to learn, and to make the learning more effective and the decision making more effective, newer data models keep on coming, newer data structures keep on coming, newer types of data keeps on coming, and people keeps on developing such things. And tomorrow the AI system would develop such new kinds of data so that it can take better decisions in faster time. Now, as of now, we do not have any comprehensive IP protection for data. We don't have. Certain countries have a sui generis system. We don't have. So we require something at the WIPO level, initiative which can percolate down to each and every nation, each and every country, wherein we look into this very, very, very seriously to ensure and to entail that yes, data is also very, very, very important. It's as important as the patent, as the copyright or as a design. It is as important as that. So unless we do that, AI systems would not proliferate. That's it.
Okay. Okay. Thank you, Utsab. Thank you
Okay.
for your speech and your deliberation is awesome, and I believe the attendees get benefited of your inputs. So
Sure.
thank you from the IPThink-Tank, and thank you. And I'm giving the floor to Mr. Oyan Roy Chaudhary. He is the Vice President of Saregama India Limited. And next to you, sir.
Hello, everyone. Happy IP Day 2020. It's a sad year, but I hope something else will prop up after this. So, after all this is over, um, presently I am working as a Vice President Legal in Saregama, but my views are not that of the company. My views and this entire thought process of whatever I'm doing here and presenting to you is my own thought process. So please let not it be taken as something which is a stand by the company. I'm a lawyer by profession, and I have some degree of specialization when it comes to entertainment industries, copyright, etc. So let me start this session. Um, the previous speaker has dwelled a lot about artificial intelligence, what it is, and how it proliferates into the world of patents, to some extent in copyright and other areas of IP, particularly data. I also have a perspective when it comes to creative industries versus artificial intelligence and copyright, and what is the future and how the future is getting shaped. Some view on how it is getting shaped, how AI is actually working to our advantage in the world of copyright to some extent. So let me first start with some graphics here, some very basic graphics. Some of these have been sourced from different material, from different sources. You see, creative industry is a huge industry in itself. Not just film industry, but it involves publishing, book publishing, copyright, the film, music, television, games, all this is part of creative industry. And the bloodline, the legal bloodline for all the creative industries is certainly copyright, but increasingly it is also patents. And it is about 2,250 billion in revenues, spanning across different sectors of the cultural and creative industries. Particularly in this scenario, what has happened in the creative industry is there are two things that has happened. On one hand, creation of new content, which requires human gathering, film production and thing, has got stalled worldwide, because this is a phenomenon which is worldwide in the COVID situation. But what has also started is increased digital consumption of content, which is anyway on the rise over a period of time. But this COVID has given us, it is showing us that it is the way the content is going to get consumed even in future increasingly. And the move is from an ad-based content consumption to a subscription-based content consumption. That shifting is something which we are watching in the content industry for some time, is also very prevalent now. That content consumption can be audiovisual content, audio content, gaming content, and similar, content. Gaming industry is on the rise, with coders and game people who create games sitting at home and creating more games. So gaming industry is on the rise. Short form video content is on the rise. Audio content creation is on the rise, but audio video creation, that is the films particularly, or television production, is in decline. However, there is an increased commercialization of existing content, given the thing that the increased consumption has increased, so increased revenue will also follow with this increased consumption of old content. I mean, one case's point is how we can see old television serials like Ramayana and Mahabharata is getting consumed. So what I'm trying to say is that creative industry is also one of the very important industries of the world. It caters to about 2% of Indian GDP and a significant percent of the livelihoods across the nations. So what is creativity? We always ponder on this question: what is creativity? We see creativity all around us. Going by traditional definitions of it, it's the imagination or original ideas to create something. Create what? It's not an innovation. The degree of newness which is required in the case of innovation is not there when it comes to creativity. It has to be new in terms of what it is getting expressed. Now, why I'm saying all this, most of you who are students or lawyers or professionals in the field of IP already might know it, but it has a relevance when we discuss artificial intelligence. So the ability to produce original and unusual ideas, or to make something new or imaginative. And please understand, these terms, new, imaginative, unusual, is contextual, in the sense that what is new and original and unusual in one jurisdiction or in one culture might not be so in another culture. So when, if you, there's enough data available that when the Indian publishing was getting developed in the 20th century, there was a lot of translations which were happening of existing content, which were basically our literary content existing in vernaculars, and they were getting translated into English, and just the vice versa in the Indian context. Many Indian creators and some of the stalwarts were also taking creativity or creative ideas from other jurisdictions. So boundaries of accessibility creates contexts, in the sense what is relevant, what is new in one context, in one jurisdiction or in a given jurisdiction may not be new because it has already been has happened there. Because of digitization now, this has become ubiquitous. These boundaries are not there anymore. So if a video which pops up here will pop up equally in other countries also. It can be seen in other places also. So a television serial made in Canada has accessibility in India also. So the extent to which it can be copied or the ideas can be borrowed is also very getting limited. Basis of the degree of involvement of human intellect, creativity can be divided basically into three types. One is combinational creativity, which is combination of various ideas, poets, writers. Exploratory creativity, which is generation of new ideas, unexpected new ideas, which is not there, a new concept in the world of creativity, not inventions, which is again a resultant of what you can say as an experience of a given cultural background. So what, say suppose an Indian visiting an aboriginal country, a country of say aboriginals in Australia, gets an idea from that jurisdiction, and he creates something in contextualizes that in the Indian scenario. Now, is that new? May not be, but the expression, if that expression is new, then it meets the criteria of copyright. The other is transformational creativity, which transforms one element of creativity into another, which is mainly in the area of designs, that what is new in a particular design can be created in a different way to create a different design. Now, these are three basic parameters of creativity, or I can say types of creativity, not parameters. So creative industry is basically a function of human imagination, that is creativity, technology for sure, human intelligence at the very heart of it, which is the romantic author, the one author who writes something. And this human author is an individual. In our romantic authorian systems, is an individual. What is artificial intelligence? My previous speaker, he elaborated on a WIPO definition. What is the Oxford definition of it? It's the theory and development of computer systems able to perform tasks normally requiring human intelligence, such as visual perception, speech recognition, decision making, and translation between languages. This is a very loose, I would say, definition of human intelligence, but more or less the kind of human intelligence which is existent today. These are some of the milestones which has already been discussed by my previous speaker, so I won't bore you with the dates and all. But the concept of author as an individual proprietor of the work is something which has been there in our understanding of copyright. It is basically founded on the concept of unique individual who creates something original and is entitled to reap benefits from those labors of creation. As you can see in 1884, around that time, there was a huge debate that started as to who is the creator of a photograph, because a photograph is a mechanical reproduction of something which you can see visually. So who is the author of that work? And initially, copyright did not cover a photographer as an author of a mechanical reproduction of a visual picture. Although there were separate provisions for artists who might also be drawing something on their own. So there is a labor involved. But a camera taking a picture is not necessarily, there's no creativity around it. There's no copyright around it. That was the decision in 1884. That decision got significant again when this one particular monkey took a picture, a selfie of its own, and the question revolved around at that time as to who becomes the owner of that particular selfie, the owner of the monkey, the owner of the camera, or the one who published it. So in between all this is again that same thing as to where is the boundary of copyright ownership. And that brings us to the very next question of who is the is the owner when it comes to copyright works. Repetitively, we have seen that the term original becomes a touchstone to decide, and it's an undefined term in all the treaties, in all the legislations. It is an undivided term. But originality is the touchstone to define what is copyrightable and what is not copyrightable. Originality, not in terms of concept, but in terms of expression, what we call as idea-expression dichotomy in classical copyright situation. But today, that is getting diluted. Why? Now, copyright is a function of originality and creativity. But what is the level of originality? How will you say that what is originality? It is just a metric of, source, designation of source, but not the function, but not the determinant factor of whether it is creative enough or not. In the sense that there has to be a labor around it. You must have done the sweat of brow to prove that you have devoted time, energy into making of that content to be copyrighted. These are all Indian decisions. I won't bore you with that. Again, the same thing, that idea expression dichotomy. And that brings us to these various AI projects or tools which are being run by different companies all over. There is a cybernetic project as old as 2003, which will create poems of its own. We can call this as exploratory creativity, something which will explore something creative, anew. Brutus, it's one of the IBM softwares, which the purpose of which was to basically create stories. It's an artificial system which will create stories of its own. Now, in the context of stories, there is something called 7 basic plots. In total, it is said that there are basically 7 plots in the world of all the stories that are ever written. And these stories are combination of whatever we write today is a combination of these 7 basic plots in one way or the other. So imagine an artificial system which basically has, okay, before we come to artificial intelligence system having that database, what is a human creativity? At the end of the day, human creativity or human cognitive faculty is a sum total of all its experiences which it has gathered in his personal capacity, or which has been passed on to some extent by inheritance. Maybe if that is there, but may not be there. But certainly his experiences based on his intelligence, whichever that person gathers. So his creativity is a result of whatever he has accumulated over a period of time. That's what a human cognitive faculty results into a creativity, right? Depending on his own intelligence and degree of creativity and um, labor he puts into. So if I have never been to Arctic Ocean, I won't be able to write a story around Arctic Ocean. Is it true? No. If I have never been to Arctic Ocean, but if I have read about Arctic Ocean, I may be still be in a position to write about Arctic Ocean. But say suppose a human being who has never been or read or have experienced in any manner about a distant land or a distant experience, he won't be able to write something or create something which he has never been exposed to. So human mind also is basically a result of whatever it has experienced. Now just copy paste this logic into what an AI does. If a artificial intelligence is fed by all the information of the world, what my previous speaker said as data, if this artificial intelligence is fed by this data and asked to create something on its own by two ways, one is machine learning and the other is by learning on its own, it develops its own system. We are not very far where creative content will get created by these artificial intelligence machines, robots. Project Magneta of Google is one such aid to give help to the musicians and the artists. It basically has all the state-of-the-art music, compositions, video, image, text, and it helps the community of artists and coders and machine learning researchers develop something new on their own. Similarly, neural synthesizer is one such machine which aids in creative process, which explores new sounds based on existing sounds that can be made. Because mathematically, and Dr. Ghosh can help me with this, mathematically, there is a limit of permutation of combination of the number of creative things one can do with the existing data. It's might be huge number, but it's still a finite number. It's not an infinite number. And that is where the question will lie as to what will happen when tomorrow systems like Brutus combined with 7 basic plots and Magneta starts to create their own creative content. Will there be because these AI will be owned by different corporations. Now these AIs, as my last speaker was saying, will not be owned by one inventor. It will be largely owned by big corporations. And there will be only few large corporations given to the cost involved in developing this AI. Only few large corporations will own these AIs. So is there a chance that story written by one particular AI will be so similar to the story written by another AI
Mr.
that it
Mr.
it crosses over? Sorry, yes,
Mr. Ayan,
yes,
sorry to interrupt. You have 5 minutes left, and then we'll pick
right.
up question answer.
Okay, thank you very much. So there is a possibility of this happening, that there will be only certain number of stories which will not be similar, which we can see today in television also, that every other serial in the television, those of you who do watch, I don't, but I come from that industry, I once in a while do watch it, and I see every other serial looks very similar, sounds very similar, and the storylines are very similar, and yet these are still written by human beings. Imagine what will happen if tomorrow these are all written by, these are all written by machines. So that brings me to the basic question: can cognitive faculty of brain be replaced by that of AI? I don't have an answer. Who will be the author of AI's creativity? There's no right answer to it. What will happen to moral rights issue of those creations? Will it be as long as what is there for human beings? Because the AI will never die, so there can't be the same rules of the copyright term cannot be applied to creativity created by the creative content created by artificial intelligence. So I don't have an answer. And recently, WIPO asked for these various policy, presentations from various groups about artificial intelligence, and it will be interesting to read what many people have suggested in this for that purpose. So monopoly of creativity, according to me, if it ever populates to the world of artificial intelligence, will or might have a very anti-competitive effect. Why? Because then it will be owned by only a few corporations. And if creativity itself is owned by few corporations, then there's a problem. It has an anti-competitive effect. But time and again, the history shows that human creativity is such, whether it is 20th century literary world, publishing world, literary publication world, or over the period of time of this entire, the digital creativity, even before that, the video creativity, it has seen that human creativity is very difficult to, contain. It does proliferate. It does get out. And in one way or the other, it wins. And even if there is an AI, the chances are that still there would be a world where the human creativity wins. So I might today think of a doomsday when there's a death of an author. An author is not required. Every other translation and everything is done by other things. That brings me to a very last few slides of mine as to what is the benefit of the AI. There are many benefits of AI which we can see today in the world of preventing piracy. What we call as DMCA plus provisions, which we have seen largely in various softwares which has been developed by YouTube, Google, Facebook, Amazon, eBay. In many of these softwares that they are developing or have developed already, particularly YouTube and Google, what has this led to, these machine learning AI systems, is that they on their own detect pirate sites and block them. Either it has to be by human intervention, by telling them what is to be blocked, or once it has been blocked, they do it by themselves as a machine learning process. So, according to me, at a global level, in order to prevent piracy, one big step which AI can help is detection and prevention But that all has to be supported by a law at the global level. There has to be an international treaty around it, where a particular site which is adjudicated as a pirate site in one jurisdiction needs to be stopped automatically without going through the entire process of enforcement of rights in another jurisdiction, but just by telling the enforcement agencies there. Project Zero of Amazon, Rights Manager of Facebook are some of the very new examples of how these websites are trying to protect the copyright, the trademarks, prevent counterfeits in their respective websites. More of such technologies has to be made available to copyright owners or intellectual property owners to prevent privacy. And just on that part of human intelligence and creativity, I would like to draw your attention to a nice film titled Onuku, which was basically written by Satyajit Ray way back in 1976. Was made into a film by Shujoy Ghosh in 2017 about a humanoid, about a human robot. Its ownership and how it gets interacted with human life. It's a very unique thing which could have been written way back in 1976 by Ray. It was made into a film recently, but way back in 76 it was written by Ray. So you see, human creativity has no bounds. Even in 1976, Ray was contemplating something which is almost a reality today, or will become a reality in next, I don't know, 10 years or 5 years. So human creativity is a unique thing. Thank you. I would like to end this with that note. This is that film, and the projections are there. So thank you very much.
And another thing, Ayan sir, thank you for this valuable speech. And I have 3 questions for you from the attendees. First one is Rima. She asked how Indian music industry is addressing the issue of idea expression dichotomy.
In the sense, it has to be a bit more specific. In what context is she asking? Music industry, how is it using idea expression dichotomy in the sense?
That's up
I'm not sure, because the dichotomy is always there. Expressions are always new and copyright protected. Ideas are not copyright protected. So in the world of music, it is always the expression which is coming across through music composition, lyrics, which are specific in expression, which gets protected, and all the connected rights around it: right of reproduction, right of translation, communication, sale, everything is connected around those rights. So I'm not really getting the question as to what she's trying to say.
Okay. And the next question is, Dinesh sir, when you talked about creative work, the most growing field is contemporary art. So how the creativity or contemporary art helps in protection of the same under copyright? This is asked by Prakriti.
Can you please repeat the question? Sorry, I didn't get it.
When you talked about creative work, the most growing field is contemporary art.
Correct.
So how creative work or contemporary art helps in protection of the same under copyright?
How it claims it is artistic work, right? Yeah. Artistic work, computer generated work, these are all protected as artistic work under copyright. Now, how it gets protected and what is again the question, basic question to enforce one's copyright comes from this fact that what is the level of originality there, and in what context and in which jurisdiction are you talking about? So what is contemporary art maybe in India today may not be so contemporary in UK or US or Australia or Japan, or what is contemporary maybe somewhere else is not contemporary in some other context. So copyright has enough provisions to protect contemporary art, which includes computer generated art also, but it has to be seen in the context of the jurisdiction where it has to be protected.
Okay. In relation to India.
In relation to India, the provisions are there. Look, Indian copyright law is stout enough to prevent, to allow protection of these works. The thing is that the law, what I call is a horse law, what is happening today, that we are developing a law. We have to make a law which is all encompassing, which is there, the provisions. It has to be correctly interpreted by the court. And lawyers play a very important part in helping the court to interpret it correctly. So that is where the lawyers or the legal jurists or scholars come in. The existing law as it stands, artistic works of expression, which are not many, may not be individual creation, but by creation of computer, but with human intervention, can be protected under the present legal regime.
Okay. The last question. Sir, could you please explain the role of privacy law in making documentaries with the usage of real names and identities from the document in the public record? This is asked by Devopriya.
Okay, so there are two things here. Please understand. There is a difference between, uh, you know, when you are making a news. If it is a news, if your documentary is in the domain of news, of sharing information, you can take information which is existing in the public domain and make those documentaries.
Okay.
But if you are creating an entertainment, work, audiovisual work which caters to entertainment, a commercialized version of it, biopics, for example, biopic of any given personality. If you want to make, most of the information is more. Suppose you want to make a biopic of, say, Sachin Tendulkar. Most of the information is available on net through Wikipedia or books written by someone, etc., etc. But can you make a film of it? Can you make a biopic of him? You can't, because it requires, because you're drawing the personality of that person. The personality rights come into picture. But if you just want to share information, i.e., it's a news, if your documentary is not a commercialized, entertaining product, it is merely an information which is trying to tell the life and time of a cricketer like Sachin Tendulkar, I think there is no issue. So the point is, will BBC tomorrow take permission of Sachin Tendulkar when they want to make a documentary of his life and time, which is informative, which is in the category of news, because news is an exception under copyright. But if that documentary falls in the category of an entertainment product, or any such information has to be put along with the information which is not there in the public domain, then the permission is required, then the privacy law kicks in. So far as the document, so the nature of documentary will determine what permission is needed, whether privacy law will kick in or not. If the nature of documentary is just informative, it's an information to the world at large, it's a news category, then it will not require, then the privacy law will not kick in. I hope I have answered the question there.
Yeah, thank you, Owen. Thank you for your valuable speech, and thanks from the side of the IPThink-Tank. And now requesting Mr. Jotwani, Mr. Dinesh Jotwani, co-managing partner of Mr. Jotwani Associates, to take the platform.
Thank you so much for having me here. I would like to thank IPThink-Tank, Dr. Pinaki Ghosh, West Bengal Law University, Dr. Jayanta Ghosh, and my co-panelist. It's always great for me to be addressing the IPR fraternity and law students. So, and I'd like to wish everyone a happy World IP Day. Just to give a little background of World IP Day, this is the day in 1970 when WIPO Convention was signed. Though from 1970 to 2000 there were no World IP Day being celebrated. From 2000 onwards, they decided to celebrate. WIPO decided to celebrate it as a World IP Day. So it's always great to be speaking on World IP Day. I was just wondering whether kind of challenging situations we have now would permit us to celebrate it this year. But the technology has helped us, and of course, thanks to the organizers, IP Think Tank on that. Okay, I'll move on to my topic today, which is disparagement challenges for 21st century. I was thinking that what is a current, when I was making my slides, I was just thinking, what is a current in this? What is current situation? And I was really surprised to see, uh, you know, this being a topic of, and this being a litigation in the COVID-19 period also. So there have been two major litigations based on disparagement within the COVID 19 period right now. So it's going to increase, and I'll just show you how this is also related to IPRs. But just to give my agenda, and I'll share this agenda. I hope everyone can see this. I'll talk about disparagement and related concepts. What is a boundary, so people can understand what exactly the disparagement, especially in the commercial world. I'll talk about Indian laws and statutes. That's very important because there is a little confusion on where exactly would we go in case of disparagement happening in the business world. Regulations, that will be next topic. Then of course, what is the position in US right now? We'll be quickly discussing that. And then some COVID-19 related cases, as I was just mentioning. Recently, the litigation has again come with respect to this topic in the current era also. All right, I'll move on. This is disparagement and related concepts. Defamation is a broader term. Basically, defamation can be civil, it can be criminal in nature. It's a broader concept, and normally it involves not it can involve businesses, but normally it involves the reputation of a person. But reputation of the companies also is a part of defamation, especially when you go into the is a kind of defamation. I will say is a subset of defamation. Uh, Sorry, this is. So it is a subset where you have the businesses, or where there's a financial loss happening because of somebody suggesting or some doing something, and degrading you or degrading your value in that. Puffery is another kind of a legal term, which actually means it's exaggerated or false praise. You know, uh, people just write India's best institute. So that kind of exaggeration, the cheapest solutions. So if you write these kind of slogans or taglines, it's a kind of a puffery, which again we'll just discuss it in the law. May be allowed, but not at the cost of putting your rival into degrading them. Then there's false advertisements. Is of course when you claim your product that it will perform in a certain way and it can never do that. So that's kind of a false advertisement. So these are all these 3 or 4 related concepts that we should understand, and there's a huge amount of a litigation going on, and especially related to IPRs, because ultimately what is happening is one or the other brand is being defamed, or uh, there is a downgrading, there is an attack on one or the other brands that is taking place. All right, so what is a boundary in it? that a tradesman is entitled to declare his goods to the best in the world, even though the declaration is untrue. So these have been case laws, and we'll talk about some of them. When I say that, it's the best hotel in Delhi, it in what sense it is? Is it in terms of food, or is it in terms of service, or is it in terms of room? Uh, that may be left vague. Okay, so if it is an untrue statement, but in some respect you can say, okay, is the fastest response law firm, as some of the law firms now do it. So whether that's true or not, these kind of declarations are allowed. Second is, you can draw a boundary where you can say that my goods are better than the competitors without naming them or without suggesting to them, even though such statements is untrue. Okay, so you can always say that, Detol is better in doing certain things, but without naming your competitor. You know, without naming, say, a soap, and we'll come to that kind of a case which has recently taken place in COVID-19, where Detol has gone ahead and said something. Third is, for the purpose of saying that his boundary is if the world, or goods are better than competitors, and he can even compare advantages of his goods over the others. You can compare the advantages what you have. All right. So, for example, you can say that my uh, solution will kill 99% of the bacteria. No other product does it. My mask will prevent 99% of the infections. So if you can prove that by way of certain experiments, and you're not naming your competitors in that. So if anything, you can highlight a particular result of a survey, you can highlight a particular result of a lab result, and without naming competitors, you can always say that your goods are best in that. However, your boundary is, you cannot say that while you are saying that your goods are better than competitors, and you say that your competitor is bad, and it's not directly that you name them, but in a way that you suggest them will also be bad in law. And it may amount to a slander, it may amount to defamation, and may result into litigation. Now there is a thin boundary around the recent cases that are happening, especially when they take place in terms of defaming a brand or an IP that is owned by a competitor. So this slide is basically talking about what the boundary is with respect to your products being advertised. I'll talk about some of the statutes that govern disparagement, and again, as I said, there is a lot of confusion. So where exactly to go? I know there are a lot of law students who are part of this webinar, but it will be good to know that what exactly is the law, what exactly is the basis. And I would say ultimately the everything, if you trace it, it will become a tort. It's basically commercial disparagement is a civil wrong, and when I say civil wrong, and when I say tort, it actually means that there is no particular statute. You can ask damages, you can ask for defamation, you can ask various other remedies, you can ask for passing off, you can ask for injunction. All these are a part of the tort. What is it? Is a civil wrong if there is a disparagement of any product that has taken place. And how it flows is, it flows from the Constitution of India. So we say Article 19(1)(a) that provides that all the citizens have right to freedom of speech and expression. Now, when we say this, we are actually going on the side of the defendant and saying it as a defense, that I have stated something right about the competitive product, which is Article 19(1)(a) will give a defense in that respect. And of course, Article 19(2) of the Constitution of India places certain limitations on Article 19(1)(a), which says that, of course, you do have a freedom of speech, but can you disparage competitor product? So that's exactly what you cannot do under Article 90. There are a lot of case laws around that, and the case laws actually originate from 1955 onwards, when these competitive advertisements came. Uh, so these are the broad laws. Of course, you can go to the Trademarks Act itself, which says that comparative advertisements, which gives an unfair advantage to a particular brand owner, are prohibited. Now, when they say prohibited, it means that if it is a registered mark, you can go for an injunction. You can go for a direct injunction on the infringement of trademarks. If it is not a registered mark, you can still go in for damages in passing of action. You can actually injunct the advertisers from using disparaging remarks against your product. Again, Section 31 of trademark, which is the basis of an Indian statute, talks about conditions when the comparative advertisement do not infringe the trademarks. A trader is allowed to use it in accordance with the honest practices that he may have in the commercial matters, so as not to give an unfair advantage or be a detrimental. So what this section says is gives limitation to Section 29(8) of the Trademarks Act, and says, on the basis of it, it says that okay, you can go ahead if it is a fair assessment or a fair comparison that you're doing. Again, I mean, these are all different statutes. We'll be going through it. Next slide. I hope you can see it. Consumer Protection Act is another statute, but I will not use it. If a client comes to me and says to file for a case against somebody disparaging the product, I will not advise him to go to Consumer Protection Act, because then the business rivals cannot, only the consumer can go. So it has a limited kind of a jurisdiction where you can go. But still, it's always good to know what different solutions exist. Then there is also a chapter 4 of the Code of Self-Regulation in Advertising. These provide a lot of guidelines on advertisement containing comparisons. In fact, there are 4 to 5 guidelines on it. I won't go into these issues, but this is a code of self-regulation. It does not have the teeth of the law. It does not have a punishment. It does not have the damages stipulated in it. But when you go to a court in a common law and say that these are the self-regulation in advertising and being violated, you can even go to Competition Commission and mention these facts. The courts do hear these self-regulation because it's an industry that has come out and regulated on its own. Then there is lastly the statute that is very important for disparaging advertisements is the Food Safety and Standards Advertising. These regulations are recent. In 2018 they have come, and there have been a case law again in this. These are mostly related to food items, restaurants, agricultural products. So anything that contains that is edible comes under this, and there are standards that have been fixed under food safety and standards regulations. So this is a new act, and there seems to be a lot of interest of the lawyers as well as courts in implementing this particular regulation that have recently come. Actually, these are regulation 2018, but they got implemented last year only. So this needs to be tested right now. So these are some of the Indian laws and statutes that govern disparagement law in India. So I'm on the regulatory agencies. Is this the slide you can see, right? So these are some of the regulatory forums where a complainant or where the aggrieved party can actually approach agreement. For example, Advertising Standard Council of India. That's where we talked about the self-regulation. Then the National State Commission of Consumer Forum. As I said, it has a very, very limited jurisdiction. Especially a lot of that jurisdiction came when the MRTP law got abolished, and a lot of these provisions were transferred to the Consumer Protection Act. But again, it has very limited jurisdiction. As I mentioned, only consumers can go there, not the rival business can go to these forums. Competition Commission of India is another forum where you can actually go and complain because it's an unfair trade practices. Food Safety and Standard Authority of India is again a new forum, especially as we talked about in terms of food articles and edible items. These are some of the regulatory agencies that are there. And of course, we have the whole judicial system where district courts, high courts, and Supreme Court of India, we can approach these courts depending on the damages. We can approach to either of these court depending on the tort, and depending whether it's an appeal or the original jurisdiction, the courts also. But it is always better to approach the particular regulatory agencies which are specialized in this area, and then approach and complain for unfair advertising that takes place. All right, the US law, I'll be very quick on this. So US law till 2017, as I said, there's a lot of evolving law that is taking place. And till recently, the USPTO was refusing trademark that had disparagement, and that included, for example, showing a Buddha for a beach wear, or name of a Muslim group that forbids smoking as a cigarette brand, or an image consisting of a hammer and a sickle, which is like a Soviet Union flag. And so these kind of um symbols were being rejected by USPTO. In fact, they are strictly being followed in as per the Indian trademark law also. And there is a whole kind of a watch that takes place on the Indian Trademark Journal to look for any mark that is disparaging to any community or a parallel product. But however, in 2017 in US law, which is evolving, it be against the freedom of speech. So what it is giving it more and more liberty to have the marks which may be suggestive of something, which may be suggestive of the competitive products. So again, this is a Supreme Court 2017, and this is particularly, if we read these judgments, the whole law is changing because of the social media, the kind of the kind of comments, the kind of the kind of feedback that is coming for the products from the social media. So the law also has to involve and interpret according to that. So this is the current US law, which has become much more lenient now as compared to what exists in India for the disparagement cases. Okay, quickly now, this is COVID-19 related cases which have happened recently now, which is HUL versus Reckitt Benskier. This is case which was reported recently, where you have a detailed hand wash, and they advertising that the soap, the bar is unhealthy because ultimately the coronavirus remains in the bar if you wash your hands from the soap bar, and so it is more healthy to have a detailed hand wash. So there is again a litigation that is going on. I mean, of course, it will take a lot of time for damages to be decided, but yes, they have got an injunction that they cannot disparage the soaps as such. Same thing has happened with the Times versus print. We all know the print is an online newspaper. They don't have the hard copy, whereas Times is a hard copy. The print came out with a disparaging article which says that a COVID-19 transmission can take place if you are reading the newspaper, if you hold the newspapers in your hand. So again, this is an inconclusive case right now. Only the legal notice has been given. The matter has not gone into the court. So these are two recently evolved cases, and I'm sure that as we go into 21st century, more and more litigation and more, especially IPR litigation related to this, is going to come to the Indian courts, and we should be ready and prepared with that. All right, this is a small quiz, and maybe we take it at the end. But yes, this is actually a real case where McDonald came out with an advertisement recently. It was full page advertisement that they say you are stuck with Ghia and Tori, and come and take a 1+1 combo, and you will love it. And there has been now a case, FSSAI case, against McDonald's. So McDonald's is of course looking for his defense. This is just a quiz and food for thought for everyone. On this I will not answer it, but yeah, we can take it probably at the end, answer this. All right, so this is a quick piece of my presentation.
Thank you, sir. Thank you, Dinesh, sir. Now I have a few questions for you from the side of the attendees. This is Praveen Bhatta. Praveen Bhatta, he is asking, is calling for support by media house for journalism defaming others' competitive media, infringing law, and can be sued?
Well, can you repeat the question? He's
Uh,
saying basically you're calling the journalist.
journalist, he's asking for journalism. Is it defaming other competitive media, infringing law, and can be sued?
Well, I don't know. I mean, in terms of disparagement. How is it a disparagement of a particular product? I don't see that as a solution. Of course, it may be, calling journalists as a community. If you call them and have them, I don't know how you are calling them, but you're incentivizing them on something and calling them and making them to do something. This is not, I don't think so. It is a disparagement as per my understanding of this question.
Okay. So along with that, have seen a media house using other name in wrong way to call support for their work. That in relation to the same. So is it
Can you repeat that? Sorry, your voice.
uh,
Mhm.
I'm repeating total whole. Is
Yeah.
calling for support by media house for journalism defaming others competitive media infringing law and can be sued? And he's telling that that the guy is telling that he has seen that some of the media are using the other name, wrong name. That means if he is from our republic and he's taking the name of NDTV to call their support in the to get the work done, is it unfair or infringe the law?
Yeah, I think, yeah, that way it will be disparagement, I will say. Then if you are using other media's name, you're calling a journalist and using some other media name and trying to defame them, then of course it's a ground for so now I understand the whole question. um, and I believe that is happening now, and of course rival a lot of litigation around the media brands now, especially during this time. We already saw, rival brands, NTTV and Republic, going into litigation on certain aspects. And of course, if you misuse the name in any respect, or make a mockery of it, in one of the cases I remember, there was a mockery also made, or you use journalist, this is of course a cause of action and a disparagement. And not only disparagement, it's an IP. You're because you
Mhm.
are actually attacking the brand of that particular media house. That's also calls for an injunction and damages also.
Okay, sir. So the next question is asked by Naika Salaria. She is asking, does Indian legislation needs amendment to protect cross-border trademark infringement?
Well, we already have something called a Border Protection Act.
Mm-hmm.
So we already have that. So if you look any product that is coming from China to India, and that has either it is not valued or it's not permitted by that company, you can stop at the borders itself. Now I don't know how it will happen in case of internet, though from there is definitely a border protection act that you can use to prohibit physical goods from coming into India that may disparage a particular product.
Okay. So next question is asked by Bhaskar. Are the Indian statute and government agencies enough to tackle the loopholes?
I would still say that we need a very clear law that is like US. The legislation still is evolving. We saw in case of food article, it is already evolved. But if you see the Trademark Act, though it is clear, but it only talks about non-registration of the trademark. How do I go to the court and seek damages under that? It does not define it. So something moving it from tort and Constitution of India to a particular legislation will be a better thing. But I don't think so. Any bill is pending in the Parliament or anything is pending which will actually make it more explicit.
Sir. And now we have our another panelist, and Mr. Subhatosh Majumdar. Uh, he will be speaking our basic theme, which is the World IP Day takes up. This is innovation for green future. So the next to you, sir, Subhatosh sir, and I will
moderators, co-panelists, and the audience. Now, this is, I should say, a Chinese IP Day, and for information, it is the Chinese who in 1999 had made a proposition when a Chinese delegation went to WIPO. They had proposed that there should be something called a IP Day. So it's at the instance of the Chinese that we have the IP Day, and today is a special Chinese IP Day. So we are happy that with all the handicap, we are still able to manage and reach out to people discussing IP, and we have IP Day and nothing could stop us. Now, I would be primarily addressing innovation for green future from the Indian point of view. And I'll just try and discuss two major aspects which I think the Indian government needs to realize and implement. So that's the theme of my talk today. Just give me a moment. Yes. So this is a definition or the gamut of green technology which I captured. I pulled out from the Brazilian Patent Office definition of green technology, where they have itemized these technology areas as far as expedited protection is concerned. So you can all see, and I don't need to read out, so you can quickly read it. So this is where the Brazilians and the several other countries, they are providing protection in an expedited manner. That's one aspect of my presentation, is that that India needs to do a similar thing. While we have amended our laws for on the front of expediting the grant of green technology patents, but that has not been done in India. So let us look at, so these are the primary pollutants or the areas of pollution: noise pollution, water pollution, air pollution, radioactive pollution, soil pollution. So this is what we deal with the green world. The world was green one day, and it's we who made it black. And even after there is technology, so this is clearly a lack of enforcement. So with whatever we have, let's say from the Indian context, we have limited technology, and with the limited technology, if you are able to enforce. The other day, somebody was talking about environment expert. He said that 70% of the pollution is due to lack of enforcement. So this is one area we need to look into. So we have to flag this item as something very important. So this you can see, this is of course some city in China, and Delhi. I think it is no different than some other Indian cities, and even Bangalore today. So this is what we have contributed to the environment, and the effects are manifold, as we know. I mean, especially it affects the health of the citizens. So these are caused by us, but in terms of technology, we really struggle to contribute to real meaningful technology to take care of this. So this is, you can see tons of emission. Now there are better technologies available, but this is again has to be taken by legislations. Now this would cost a bit to our country and a bit of problems. It's more of a economic aspect, but we have to reform. Like we are in a lockdown, we had to enforce it. It's something unthinkable till about 2 months back. So we have to get rid of pollution. We have to clean our environment to have a better future for the next generation. So you can see this is contamination of water. So the water pollution in the Indian rivers and other water bodies, like even the seas, they're polluted. I mean, you've seen the oil slicks and other stuff. So this is made by us, and this sewage can easily be treated by different treatment plants, etc. But the government should be more careful, because the private enterprises, they may not be eager to implement such measures, but then it's again boils down to the implementation, which is most important. So this is one scene which is not uncommon. So we can see that plastic and all sort of garbages all around in the water bodies, and that makes the eco life unfriendly and our future bleak. Now this is a video. I don't know whether under the conditions, whether it can get. I'll just start the video, see if you can see it.
The majority of my childhood was always within the water. There's nothing worse than being out there surrounded by plastic. I was a product designer in another life, and it was my job to make plastic products. And after a while I realised that we didn't need the stuff that I was making, and so I stopped. I met Andrew and he told me about this project, and it just clicked. For me, the project was amazing. We could have a better time at the beach because we're not swimming in plastic and pollution anymore. We'd even eat better because the fish are healthier. Marinas, ports and yacht clubs is the perfect place for the sea bin. There's no massive ocean storms. It's a controlled environment. It catches everything floating in the water: plastic bottles, paper, oil, fuel and detergent. 24 hours a day, 7 days a week, 365 days a year. Another good thing with the location of the sea bin is that people can see what we're catching, what they're swimming in. It's been a big change in our life. We quit our jobs, we've taken all our money, and we're putting our heart and souls into making this happen. One of our goals is to make the sea bin from our own plastics to create another sea bin to capture more. It's a domino effect. The second goal is to create a world where we don't need the sea bins. Imagine that. We have a pollution-free ocean for our future generations.
Now, you saw a video. Now, you can see that it's a very small device, and there are many people here who are from the IP space. So you can see that this device can be protected under patents, under designs, and if we had a law of utility models. Now, what is a major concern is if you look at this table, which shows the date of grant, which is on the right-hand side. So these are the dates of grants, as you can see. So these are fairly recent, and September 2019, January 2020, and again 19. Now, these technologies we needed yesterday. So if something is invented today, it should be available to the people on the very same day or the next day. Now, if our IP system is addressing such environment-friendly technology, so you can see that this is an application which was made in 2011. It took 8 years to grant a patent. So who needs a patent after 8 years? I mean, as for some technology, when people are dying, when the environment is degrading, the next one takes 10 years. Here is something which takes 2007, 4 years. And here something which is 8 years, 9 years really. So this is where we need to work, and I'm going to show a few slides what the other countries are doing. Now this requires, India doesn't have to go and sign a legislation for that, just needs to have a rule. As you all know that we have Rule 24C, where provisions have been, there are multiple provisions for expedited examination. And let's quickly see that what the world has done. Now, let us look at our sorry, this link is not working. Now, 24C, most of you are aware of the categories of the applicants. So it's applicant specific and it's not technology specific. While the rest of the world, the major countries are trying to attack or trying to address this problem from a technology specific, that's green technology. So UK was one of the first. So you can see about UK in 2009, they came in, and so it's more than 10 years that UK thought about protecting green technology by providing the grants early by way of accelerated prosecution. Then we have Australia, 2009 also, again 11 years ago. We have Brazil, 2012. They had a pilot scheme first, and then they provide for expedited grant. Canada, 2011. So they're all about 10 years ahead of, I mean, I wouldn't say ahead of us, because even today we don't have a technology specific expediting procedure. China is 2012. Israel was also way back in 2009. Japan was 2009. Korea was 2009. Taiwan was 2014. US had something as a pilot plant, I mean, for 3,500 applications. But in US, the patent prosecution is generally much faster compared to other jurisdictions. So they don't need a separate mechanism for addressing this. So this is an overview. So what's important is that now what is the benefit, or what do we try to get from the seminars, is to focus on a couple of issues and where possible take it up with the government. So I think a burning issue is to amend the rules so that the provision for accelerated examination should be technology specific. As I showed you the definition for Brazil, it's very, very, there are diverse areas of technology. There are diverse ways in which the environment is being polluted. So this has to be captured, and this is a priority area which unfortunately India is not addressed as of date, so you can see a big no for India. So that's not good news for us. So this is something where we should try and make a representation to the government to look into it. Now, another angle which is most important is that now India is not a major technology generator, although we have unlimited intellectual resources. We have people who are very clever, but having regard to the fact that we have millions of SMS small units, but we don't have a law, the utility model law. So let's try and quickly have a look at I'm trying just a moment. So this is about utility models. I don't know, there's something problem with the link. We have more than 70 countries, starting from Albania and other countries which are third world countries, right up to Japan and other countries which are first world. I mean, Japan is a third world country, but I'm talking of all the majority of the US, US, the European countries and US, they have adopted and this is for small innovations where you don't need the feature of inventive step, and it is somewhere in between patents and designs. In designs, as you know, that a design protects the external features of a product, and for patents you need novelty and inventive step. So utility model fits in between, and this is most important and critical that India should have a utility model law. But I remember that before 2005 law had come into force, there was a joint parliamentary committee which was set up, and I had deposed before that committee. This was way back in 2004. And even at that time, it was discussed that we should have a utility model, but I don't know eventually why didn't the legislators consider it appropriate to have a utility model law, which is for a limited period for small innovations. And I will show you something very simple, which is a good model for a utility model, which is just start this. This doesn't have a audio, but you can see it's.
Sir, it's working perfectly.
Okay. So you see, what you saw was a sponge, and a sponge which is of a special type. Now, we do not know whether this would be patentable because there are features of inventive step. We do not know the large loads of prior art, which may be talking of similar products. But
Sir,
if
you have
India has,
sir, you have 6 minutes.
okay. So, and then for question answers, a few minutes for, or should I
Yeah,
stop
question
in?
answer. I will ask question.
So I
You have
have another
presentation for 6
2
minutes.
minutes or what?
Yeah.
Okay, fine. So utility model is a law or a piece of legislation which we must have. We had to have long back with a large load of the SMSE. But then the legislators felt it appropriate not to have this law, but we must have it because the large number of small innovations which get unprotected can be protected. The other thing is that the term of such utility patents are usually less compared to patents. In some most of the countries about 6 years, and in some countries it's 10 years. And the best part is that you don't need a separate office for that. The patent office can take care of that. For the simple reason is that it will become a part of the patent law or a separate utility model law, where you apply for a patent today, and tomorrow when you are faced with an objection of inventive step and you find that you are unable to address the inventive step objection, you can convert your patent application into a utility model application instead of getting the patent application rejected and losing the invention as a whole. So you get limited protection, and apart from that, if you get protection quickly, that would be an additional motivation for people to actually disclose their inventions and make it available in public domain. And if there are legislations which can expedite any litigation for enforcement, so that will help. As you know that in Indian courts, litigations go on and on. So it's again very important that we should be able to enforce the IP apart from generating IP. So this, as I was mentioning, that with a large number of micro, small, and medium-sized enterprises, UM is a solution which we must have. So thank you, and I'd be happy to answer any questions.
Yes, sir. I picked 4 questions, so for you. This is Arushi. She is asking, sir, can you emphasize on the role of traditional knowledge and indigenous people? How do they contribute towards providing a green future?
See, indigenous knowledge as such, which is in public domain, indigenous knowledge is something like traditional knowledge. Now, traditional knowledge is something which is in public domain, so you can't protect something which is in the public domain directly, but you can prevent others from stopping monopolization of traditional knowledge. So, as such, there is no protection of traditional knowledge in the form of IP as such, but you can prevent others. And then we have mechanisms for compensation of through the NDA system, where the applicants for patents or applicants, anybody making products, they can secure licenses and compensate the traditional knowledge owners, the communities who are in possession of such knowledge.
Okay.
So there would be a benefit sharing scheme which
Yes,
is in
sir.
place and it's being practiced
Yes, sir.
under the biodiversity law.
Yes, sir.
Biodiversity addresses that. Yes.
Okay, sir, this is Ayushi. She is asking, it can be clearly seen that the environment conditions are improving due to lockdown. But after lockdown is lifted, what measures can be taken to keep healing environment around us to intact? What provisions are government already and already have taken, and what perspective in IP law?
See, firstly, the lockdown is something which was unexpected, and now IP law doesn't have. Yes, we have environment laws. There is a pollution control board, and there are other bodies to prevent. So we can go through such provisions, and at the highest, from the point of view of the Indian law, we have Section 3B, and we can stop protection of any damaging technology. For example, there was a notification from the government last year on this Tobacco Act, and this electronic cigarettes, and a few applications have been rejected, which were in the area of electronic cigarettes. So that is where the patent law can address, but the patent law is primarily concerned with innovations, and if you're misusing the environment, if you create bad technologies, patent office can tell you that we will not grant you protection for bad technologies, but it doesn't have reach beyond that to stop pollution. And I think it's we have to be now. You can see that in India, lockdown, I mean, a large chunk of people are not respecting it. So we have to appreciate, and we have to appreciate that we need to have a clean environment and leave something for the generations to come. So here, the use of the application of the IP laws are limited as far as this aspect, which has been raised.
Okay, sir, the next question asked by Devopriya, she is asking, please highlight on protection of green invention under Indian law, and if at all proper need is paid to commercialize such product or invention.
See, as I mentioned in the course of my presentation, is that we don't have technology-specific protection, as you perhaps, as the questionnaire perhaps is aware that there is Rule 24C, which was amended last year, and it provides that who are the applicants, the type of applicants who are eligible to speedy or fast track grant. They are startups, small entities, natural person, at least a natural person who has to be a lady, or at least one of them has to be a lady. Then some departments of government, but that's what I tried to put in my presentation, that there should be a strong representation to the government that green technology should receive a special status, because our law doesn't provide that that certain areas of technology should be given a special status, and that is what is required. And that's a very good question. So we should push the government that no harm would be caused. So I mean, if you take 10 years to grant a patent for this green technology, so it becomes wholly meaningless at the end of the day.
Okay, thank you, sir, for your valuable speech. And on behalf of IPThink-Tank and Pinaki sir, we are very grateful to have you here, and for your valuable time. Thank you, sir. Now I will move on
Thank
to
you so
the
much.
yeah. Now I will move on to Sumantra. Sumantra Mukherjee, please. Sumantra Mukherjee is the director of KPMG, and now he will take the lead. Yeah.
Okay, great. Thank you so much. And thank you to all of you, and to all the panelists for giving us such wonderful insights about the various facets of IP. And So this is going to be the last session, the session which is kind of holding you between the Sunday lunch and maybe an afternoon nap. So I will not take more than 20 minutes. I will keep my presentation short. So as almost all the speakers did mention, and I'm also mentioning that the views represented here are my personal views and not that of KPMG's. So in the last 1 month, since the time the lockdown started, I've attended close to 100 odd meetings. I would say almost like 4 to 5 webinars and Zoom meeting, team meetings, WebEx, and this is kind of one saying that I've heard in most of those meetings. I would say almost 90% of those meetings is that special times call for special measures. I've also heard an alternate version which says unprecedented times call for unprecedented measures, and seriously so, because if you look at the last 1 month or 1.5 months or so, our life has kind of turned upside down, right? So we have never imagined life like this, right? So we have seen something which was a global financial crisis in 2009, 2008 period, and some of us on this call might have also kind of gone through it. But what we are seeing now is something that we have not seen. So the topic that I'm going to talk about is what the future is going to look like for IP commercialization. And to be seriously honest with you, I don't have any idea how it's going to look like, because we all are grappling with a lot of uncertainties in our future, right? So we hardly know how the disease is going to kind of stop, and we are going to get control of this particular disease. And then, of course, the resultant lash in terms of what's going to happen to the economy, how fast it will recover, how will the world change, what will be the new normal. And in the last one month or so, we would have seen a lot of things that we would have not done in the past. We have seen our children studying in schools, but from home using laptops. We have become much more proficient in the household work. So a lot of these changes have happened, which have kind of, I would say, made us a better person at the end of the day. But yes, these are tough times. So what I want to do first is, before I talk about the impact that COVID-19 will have on the commercialization aspects, let's talk about what are the various ways in which we can commercialize, right? So the first basic thing that we can think of is the products. So the technology, the patent, the copyright, what goes into a product, that forms the majority part of the commercialization that happens through IP, right? So I create a product, I file for an IP, I get that IP, my product becomes unique in the market, I go and sell in that market, I make money, and that's how my business progresses, right? So we all have products. So that's the major, that's a major form in which we commercialize. Then comes technology transfer. Now in technology transfer, what happens is that there can be certain core technologies or non-core technologies which we can lend to somebody else to make their businesses better, right? So an example of a technology transfer can be a company creating some sort of software solutions, hardware, anything which kind of helps another business to reduce cost or increase the efficiency of their business. Thereby, they start using their technology. Or another business which might have their core business in something, they would take technology from other businesses which are non-core to them and make their business work in a better way. So then technology transfer is another form of commercialization. The third, what I called, is holding the gun. Holding the gun is nothing else but licensing through infringement. And we all know that when I have got a patent right or a copyright or any other IP rights being given to me as an organization, and if I see that somebody else is willingly or unwillingly, for that matter, is infringing on my patent rights and thereby causing harm in terms of my revenue collection and my business spread, then I would go after that person to say that please do not use my intellectual property. And if I mutually agree that okay, that other person has to use, then I make revenue out of that as well, right? So that is the third form of commercialization. The fourth form of commercialization is content. Now on content, Oyon gave a very good speech in terms of how content is getting monetized, and more so nowadays. We are all glued to our EDA boxes. We are watching Netflix, Amazon Prime, Hotstar. Our kids are going to multiple training websites. They are learning stuff online. A lot of online content is being made available for free. And that's we see a barge of online content being generated and produced right now. So that is the fourth form of commercialization. And the fifth is brand, right? So a brand helps us commercialize. So KPMG is a brand, for example. Tata is a brand. Aditya Birla is a brand. Apple is a brand. We know many of the brands, right? So brand, the way the brand conducts itself, the way the brand positions itself in the market, also has a lot of parameters, and it affects the total value building of the organization. So now what I'm going to do is I'm going to talk about how these 5 aspects that I spoke about is going to get affected through COVID-19. Sorry, I missed trade secret also was the 6th one. So on a product space, what I see is that the impact is going to be high. The impact is going to be high because it's going to be a factor of how the demand of a particular industry is going to pan out compared to few other industries. Now, if you would have looked in the last 1 month, you would have seen that sectors like e-commerce, pharma, technology platforms, and essentials did not have a negative impact on the growth of their businesses or the sales for that matter. There might have been a constraint on the supply chain, but otherwise, these businesses have not been hit majorly by COVID-19, or they have not been affected adversely by the COVID-19. But if you look at certain other sectors like travel, tourism, hospitality, real estates, these got badly hit by COVID, right? So, you know, for the last 1.5 months, there has been no travel, right? We are all doing our meetings through WebEx or online platforms. There have been many a situation in the past wherein we used to travel a lot to conduct meetings. Tourism used to be a big industry, and all of them have kind of gone into a slump altogether. So those are the industries, and their products necessarily and their IP will get hit because of COVID, and the resultant economic backlash which will come in the next few quarters. Now, out of this, if you see, automobile is going to be an interesting sector, because in automobile there are two views, right? So one is that people may not want to buy a car right now because that is going to be a capital investment for the individual. But if you look at the other side, people will also not be very comfortable now in traveling, say in a metro or in a local train or in a Uber pool, right? Because of the social distancing norms, right? So what will happen is that as a result of this, we will see that new business models will evolve. So in an automobile sector, for example, people might see trends wherein subscription model of owning a car may come, wherein you can pay a certain amount of money on every month, and then use a car on a rental basis, wherein you don't have to pay too much money to block your capex, and at the same time you can also maintain the norms of social distancing. So we will see a lot of innovation around the business models. We might see that the companies might delay their product launch. People will be very focused in terms of their R&D spends, their marketing spends. People will be highly focused on ensuring that customer loyalty is retained. There's a good amount of engagement with all the customers which are there, because right now it is very easy for us to switch brands, and sometimes we may not even consider brands as our first priority because we are all looking at essential commodities. One of the boons of this is, of course, that a lot of countries are talking about localization. Now, what localization means is the Make in India concept that we were talking for the last few years, and that will also give a lot of impetus to a lot of Indian firms to develop their own technology and start producing, right? So that we can become more of a self-reliant country. Now, coming to valuation of products, the valuation of products in this particular case will depend on which industry or sector it is part of, right? So, for example, a valuation of a travel company is likely to be hitting the bottom right now, compared to an e-commerce company, or a pharmaceutical company, or a technology platform company like a Zoom, wherein we see that the valuation is going through the roof. So that's how the difference we will see. Moving on to technology transfer, I feel that it will have a medium impact on technology transfer. So people where they have already invested in a kind of technology transfer which is undergoing, I don't think that they're going to stop that. They will still go ahead with it because there already has been some amount of capital investment which would have happened, and nobody would want to make that into a sunk cost. So the technology transfers which will work will be the ones which will have a low capital investment, which will increase efficiencies of business and decrease costs. The ones which will not work, of course, will be the huge capital investment, because everybody is trying to preserve cash right now. So people will not want to make huge capital investment unless absolutely necessary. People will also be a little skeptical in using alternate technologies or situations wherein there has to be a system overhaul. So for example, if I am to use a new technology and I see that because of using a new technology, I have to overhaul my entire ERP system which is there in the organization, I will put that particular thing in at hold. Similarly, like I mentioned about automobile in my last slide, automation is going to be something which is also be a dual-edged sword in this situation. One, automation, of course, will come into the business. AI, ML will come into the business because that is going to increase efficiency and decrease costs. That will also help organizations to understand what they're going through in terms of their customer demand, running analytics on their customer preferences. So those things will be essential. But at the same time, if you look at a country like India, wherein the demography is of hugely populated working class, then the organizations would have to think through in terms of how do they reskill the existing manpower so as to not increase the number of unemployment within the organization. So from a business model perspective, again, technology transfer would be need-based. There will be a lot of scrutiny happening before they would indulge in any such decision, and it will go on a slow mode. From a valuation perspective, again, the valuation I feel will go down compared to what it would have been pre-COVID for a same technology, because the propensity for the buyer to pay will now reduce, and you will see more deals happening wherein it will be more of a revenue sharing or profit sharing rather than an upfront payment being given on technology transfers. Moving on to the infringement-based licensing, this is where I believe that we will see a maximum increase, as Dinesh was also talking that he, as of now, sees a lot of litigation. And this is a similar trend that we saw in the 2008-9 recession period as well. So there were a lot of companies who would now scout for what kind of patents they are holding, what kind of copyright they are holding, and see where they can find more money, which are sitting idle with them, right? Again, this will also have similar impact. So as the sector is doing well, you'll see more litigations on that sector, and the sector is not doing well, might not see that much litigation because people are already struggling over there. So it will be important for the businesses to manage their risks. So the businesses would have to understand that they have to ensure that their products, their solutions are not infringing on anybody else's IP rights. Otherwise, managing the litigation cost might be difficult for them, right? And what they will also start doing is to prune their non-core assets to see whether they're making sense to keep them just lying idle, or they will try and identify that if out of them something can be monetized. Valuation will be a plus here, again, because if you are able to identify, say, a patent or a copyright or any IPR, and you find somebody else is infringing, and if that other party is in a sector which is booming, like for example, a content industry or an e-commerce industry, then people will go ballistic and would ask for higher money and higher damage right now. Now moving on to content, the impact I feel will be low. The reason being, content was in which case moving online. We had already seen that trend started a few years back, and that had worked well. And we see that during this time, there has been a spurt of online content being generated and online content being commercialized. So you will see more education, more trainings, more movies, more songs. The thing that is not right now in vogue is the hard copies of this electronic media, right? So most of the people are switching on to online phone-based apps to kind of go through newspapers, and people are not going through newspapers, though it's not true, but I think people are avoiding. New content, right, in terms of movies, for example, might become difficult because of the social distancing norms. So over a period of time, I see that to be an issue as well, wherein content generation, specifically for the soap operas and the movies that we see, might have to change, and their business models will also change. On the valuation bit, I think content will sell at a premium right now, because that is the only way of comfort and leisure that we have. And people are going to use this mode only as a relaxation. So this is good.
Sumanta, if you finish it in next 2 or 3 minutes, it will be very
Sure.
easy.
Sure. Okay. So so this industry is going to boom, and we are already seeing examples of that. Then comes brand. So brand will also have a high impact, pretty much like the products. Now, the brand building at this time would be very important, right? If you see, a lot of companies are doing a lot of CSR activities. A lot of companies are helping the society in distributing food, distributing masks, sanitizers, and also helping a lot of people. Say companies like Tata. I'm just taking one example without being biased on anybody. They have kind of made their hotels available to be used by the medical staff and fraternity to use them during the quarantine period. That was a very nice gesture from their end, right? So people remember all these kind of things, right? Reskilling of people and supporting the employees would be an extremely critical on a brand building part, right? When I say supporting employees, as I've seen my organization doing, they are almost in constant touch with each and every employee, trying to know about their health, about their well-being, ensuring that there is not even a single person who is being retrenched. These all factors can create a lot of value addition in terms of your brand building, right? What will not go well is taking wrong decisions, which will land you into litigations, not managing your risks properly, which can land you into litigations, or panic decisions uh, of laying off people because you cannot sustain right now, right? So all of these will kind of have uh, quite a bit of impact on brand. From a business model standpoint, brands would have to stay invested, and they have to be nimble. Valuation of the brands will again depend on how people see the brand, and also again on the industry it is part of. Coming to my last slide, which is on the trade secret. Sorry, I missed out on talking about the trade secret part on the first slide. But on the trade secret, I feel that it will have a um, uh, similar rationale being followed as we discussed during the products. It will have sectoral impacts. Companies who are predominantly relying on trade secrets and know-how, but having a low date. Low date means that they have not borrowed too much money from outside the company, would survive in a better way compared to a company which has got higher debt values. The other thing that the companies would have to watch out for is theft right now, because people would be vulnerable right now, and in the end, you might lose on your trade secret. The valuation of trade secret again will depend on these factors that I spoke about. And overall, if you see, I would say that COVID-19 would have an impact on the valuations. For some industries, it will be positive, but in most of the cases, it will be negative. So that's where I would like to conclude and hand it over to Jayanto. Thank you so much.
Thank you, Sumanta. So I have some questions for you. Please be on specific to the issues what the attendees wants to know from you. How you see the post effect of COVID-19 of pharma market?
So I see that the pharma market will not get affected with the COVID-19 situation because the medicines are essential, so they would still get consumed. So it will not see a demand side reduction. The only challenge which the pharma companies might see would be on the supply side of things. And that is what they have to manage so that the demand side can be kept under control.
Okay. There's a Lena. She is asking, in pharma company, while concluding licensing out agreement, how to address the issues of IP involved in standardization in specification owned by company?
So I think that's not going to change. So if you would ask me, Lina, the COVID-19 situation will not change the way it used to be handled in the earlier days as well. What might impact is the value which it might fetch, but I don't think that the process will get altered.
Okay. The Arushi, she's a Arushi Rilan. She is asking, can you put light on the effect on share market or Sensex post lockdown?
See, we have seen and we have evidenced this that the Sensex has kind of behaved quite erratic post lockdown, and like it affects and the Sensex affects based on the people's sentiments and the way the economy is kind of going. So see, I'm not a share market expert, but then at least with my limited knowledge, I can only say that it's going to go down and it's going to take a U-shaped curve over a period of time. I think the way the country is handling the COVID-19 situation is commendable, and that's kind of keeping the boost of keeping the market sentiments high. But then definitely because of the lockdown and the economic loss that we are having, and there is a time lag to start the economy, right? So that will of course have an impact on the stock market.
And
Needless to say.
Yeah, and there's another question. It's related to IP attorney. How do you think that IP community will affect due to lockdown, and will companies to be motivated to spend on IP attorneys? This is asked by
Yes,
Swati.
I think definitely yes. See, IP is something that will stay because IP is something that differentiates one organization from the other. So IP will stay. There is no question. And if IP is here to stay, IP attorneys will be required, right? Now, what might reduce over a period of in the recent future, I would say, is the people will not want to file frivolous IP. People will concentrate more on quality IP and ensuring that the money spent is well spent.
Mhm. Thank you, Sumanta. Samantha, be online. There are two other panelists also joined with us. This is the vote of thanks session, and can you unmute your audio, Dinesh sir and Majumdar sir? Mm, Yeah, Dinesh sir, you can speak of. Yeah, if possible, everyone can come on video also. Yeah, Sumanta, if possible, you can also come. Yeah. So it's a great honor for me to have this panel on this very auspicious day for IP, and we are devoted ourselves to IP somehow. And now it's I will request all of you one by one to share something as. And now it's attendee, almost 131 attendees are there. They are still be with us online. They are listening us, and they can see us also.
Right. I think we should start by thanking the attendees. And I know at the peak of the time, I saw around 350 participants. So yeah, I mean, we should start by thanking them, and then we should also thank the organizers, IP think tank, which is behind this organizing this wonderful webinar on the World IP Day. Dr. Pinaki Ghosh has been a force behind this. He's a silent force behind what is happening today. And all of the panelists, I would like to thank them with the immense knowledge. I mean, you are always a learner in these kind of an event. So thank you so much, everyone, for having me here and for such an interactive session.
Yeah, from Majumdar sir.
Well, I would certainly say that it was a special day, and I remember the Indian Patent Office had celebrated the first IP Day that was in 2004, and I think the first IP Day was in 2000, the year 2000. So on the same day, I was in the Calcutta Patent Office and in the Mumbai Patent Office, taking the first session in Calcutta and taking the last session in Mumbai. So the vibes were more kind of positive. Well, I wouldn't say that they're not more now. It's more technology based, but we are happy that despite all the constraints, we could make it happen. And with the last moment change of platform, etc., where Jointo updated us that look, the numbers are beyond control. So thanks to Jointo and his team for being able to handle a last moment kind of big spurt of the number of attendees, and still we could make it. And I'm happy that we could make it happen, because for us, this is the day which is reserved for us as
Yeah,
professionals. Thank you,
thank you,
everybody here, and
thank you.
these
And
people
Sumanta
who are
sir,
still there.
speak online 1 minute, because we are running out of time. It's
No, no,
within
no.
3 minutes it will
I,
be end
yeah, so
automatically.
I would like to say thanks to everyone, including all the participants who have taken time out on a Sunday to join this session, and I really enjoyed hearing all of the panelists as well as also listening to some of the brilliant questions being posted by the individuals. So a great experience in all, I would say.
Thank you. On behalf of IP Think-Tank, I share my heartiest thanks to all the panelists. Majumdar sir, Utsab, and Ayon is not here, so sharing my thanks to, and Sumanta sir, Dinesh sir, and many thanks to Pinaki sir, because he is one of the person who is behind this, and my whole team who is effortlessly they are working like anything, and taking the name Nikita, Abhishek, Bhaskar, Otish, and Chandrika, they are working like anything. So for this event to be the successful, and this is all from Think Tank, and we are happy to host you all any time in future in any say any platform like this, and hopefully we will organize a grand event again, and we will continue our contribution to the legal fraternity and IP fraternity too. And with that, I would like to conclude. Thanking you all, and thanks to all the attendees who are joined here, and uh, we expect that same kind of responses from the attendees too in next future event. Thank you all.
All right. Bye
Thank
bye.
you.
Bye bye. Bye.